Good evening, everyone. Thank you so much for joining us for the closing panel of the first day of the Emerson Prison Initiative's conference on equity, access, and education for incarcerated people. And it is my pleasure to moderate this final panel of day one. I know a lot of you, but for those of you that don't know me, I'm Manisha Gelman. I'm the founder and director of the Emerson Prison Initiative. And it is really a pleasure to get to introduce the three panelists that we have with us tonight. I'm going to read them in the order that they're going to speak, which is not the order that we are seated. So first up, Calvin Arey in the middle here directs the Alfred Woodfox Memorial Mini Freedom Libraries, a fiscally sponsored project of the Prison Book Program. Calvin was incarcerated for almost 18 years, including 8.5 years in Virginia and 5 years each in Connecticut and Massachusetts, all between 1965 and 1989. He's the only surviving lead plaintiff from the landmark prisoners' rights case, Landman versus Royster, which desegregated Virginia's prison system, established basic due process rights for incarcerated people, and put an end, among other things, to bread and water diets for people in solitary confinement. Calvin's history-making life and his freedom libraries have been chronicled in Richmond Magazine. So welcome, Calvin. It's such an honor to have you here with us. I think let me go ahead and read the bios for each of our guests, and then we'll speak one by one. Off the cuff, I will also offer that Calvin was the inspiration for putting on the whole conference to begin with, because he has so dedicatedly come to so many Emerson Prison Initiative events year after year, and in chatting with him at each of those events, we're like, wait, there's a really important story here that we want to figure out how to lift up. So it was actually in conversation with Calvin over the last couple years that we realized we needed to do a bigger event. So thank you for inspiring this conference, Calvin. To Calvin's right is Michael Millemann, and he is the Jacob A. France Professor of Law at the University of Maryland, Carey School of Law. From 1968 to 69, as a law student, he worked with Philip Hirschkopf, a civil rights lawyer, on several groundbreaking Virginia prisoners' rights cases, including ones in which Calvin Arey was a plaintiff. An article by Hirschkopf and Millemann, The Unconstitutionality of Prison Life, was published in the Virginia Law Review in 1969, and it describes those cases. Michael has fought many years for prisoners' rights, first as the National Prison Project and the Maryland Legal Aid Bureau, and then as a law professor. He's published extensively, including in criminal justice and prisoners' rights field, and has received many awards for his varied teaching, program development, and legal work. He graduated from Dartmouth College and Georgetown Law Center. So welcome, Michael. And third to my right is Elizabeth, or Lizz, Matos, and Lizz is the Civil Rights Division Chief and Senior Advisor to the Attorney General here in Massachusetts. Between 2018 and the summer of 2023, Lizz was the Executive Director of Prisoners Legal Services of Massachusetts, or PLS. Lizz has been involved in litigation about solitary confinement practices regarding prisoners with mental illness, discrimination against deaf and hard of hearing prisoners, draconian classification practices, guard on prisoner assaults, and lowering exorbitant and monopolistic prison phone rates. Before her executive director appointment, Lizz worked as staff attorney at PLS and previously worked as a staff attorney at South Coast County's Legal Services, where she practiced housing, education, disability, and immigration law. Prior to law school, Lizz worked in the immigration field for several years and was a Fulbright scholar in Mozambique. Lizz is on the council of the Boston Bar Association and is a graduate of Brown University and Georgetown University Law Center. Welcome, Lizz. So the format, just so you know where we're headed, is I've invited each of the speakers to take about 15 minutes to get to talk about the theme of this panel, which is rights for incarcerated people, and then after that we'll have time for open discussion. So we'll go ahead and start with you, Calvin.
Well, for context, I think I'd like to start off by saying that I'm an alcoholic. I've been sober now for 38 years, but you know how it all started for me was back in 1965. I was stopped and arrested in Virginia after a series of armed robberies to get the money to keep on drinking alcohol. And within a few months, I found myself in the Virginia State Penitentiary with a sentence of 30 years. Back then, that prison was 165 years old. It was an old prison. And it was a Jim Crow prison, totally segregated. Before the end of the year, I was put into solitary in a building in the prison called C Building. It was a prison within the prison. And they brought me over there, brought me down to the basement. I was stripped, given a pair of pants, a shirt, socks, a little face towel, and a roll of toilet paper, and locked up in one of the solitary cells. Now back then, it was a silent system. You had no, your cell was isolated, you had no one to talk to. And you had nothing, no books, no toothbrush, no toothpaste, no nothing. You were only released from the cell once a week on Saturday mornings for 5 minutes for a shower. And you were fed bread and water, 4 slices of bread in the morning and in the afternoon, 2 days in a row. And then on the third day, 2 reduced meals. By reduced, I mean it was 1 scoop of whatever they served in the regular mess hall, and no bread, no dessert. So, I mean, basically everybody lost weight in there. And you didn't receive any mail. I mean, you had nothing, really. And so, for the first day or so, I was racking my brains. What do you do when you don't have anything to do anything with? And at that time I was 23 years old at the time, and I'd bitten my fingernails all my life. I'd never had fingernails, so I said, that's something I can do. I can not bite my fingernails while I'm down here. And so I put my hands behind my back and I walked back and forth. I could only walk 3 steps in one direction and 3 steps in the other. But for the rest of that month, 30 days, I didn't bite my fingernails. And I don't know if you can all see them, but that was 60 years ago. And I've never bit them since. So when they came down to let me out of that solitary cell, I could claim a victory. I maybe one of the few victories that anyone could claim after that situation. And I was brought upstairs. A C building was, you were all in solitary confinement, whether you were in the basement or upstairs. Upstairs, you were locked in a cell by yourself. You could talk to other prisoners, though. And you got fed 2 meals a day, and you were locked up 23 hours a day in that cell. You had like an hour out on an exercise yard. If you weren't padlocked in the cell, which was the third way, the third form of solitary. By padlocking, they would lock your door so it wouldn't open when they opened up all the doors, the other doors in the tier, and you'd stay in the cell 24 hours a day, get fed in the cell, and only get released once a week for a shower. I experienced all 3 of those different methods of solitary confinement for the next 4.5 years. I didn't get out of there until 1971. From 1965 until 1971. Now, while I was in C Building, I met another prisoner, Robert Landman, who was, the term is jailhouse lawyer. He was very experienced in filing mostly petitions for writ of habeas corpus or cases in the federal court under 42 U.S.C. 1983. Is that right? Yeah. You'll hear from him next. He was my lawyer 57 years ago, so, And he's been in law all this time, and, you know, I've been not in it. So, but anyways, Bob had written, he'd helped an awful lot of guys, over 2,000 guys file petitions in the courts during his years in the Virginia state prison system. And he showed me, you know, I learned from him. And how I learned, he had arthritis, and he couldn't, you know, print very well. And we had to make 3 copies of every petition. And so we'd get the carbon paper and the legal paper, and he'd write a draft, and then I'd write it out. And I could print pretty good, even though at the time I hadn't finished high school. And we started filing. The first case we filed was one for myself. And because Bob had gotten in trouble for writing petitions for other people, we said, we're going to do this, you know, on the up and up. So I wrote a letter to the warden asking for written permission for Bob to help me. Within 5 or 10 minutes, I was padlocked in my cell just for writing that letter. Well, that provided grounds to file a case in federal court, you know, for interference with my access to the courts. And so that was the first case. And I actually won that case. It took about 2 years, but it went up through the United States District Court to the Court of Appeals, and they reversed it in my favor and sent it back down. Well, you know, the first couple of years in that building, it was pretty lonely. You know, and you know, we were like in the middle of the civil rights movement. It was a Jim Crow prison. In 1966, in June, I think it was June 6th of 1966, Bobby Kennedy went to South Africa, to Cape Town, and he gave a speech. It's called the Day of Affirmation speech, and sometimes it's called the Ripples of Hope speech. I've written down, I copied down, we had a copy, you know, it either was written about in a magazine or in a newspaper, but in part it said, each time a man stands up for an ideal or acts to improve the lot of others or strikes out against injustice, he sends forth a tiny ripple of hope. And these ripples build a current which can sweep down the mightiest walls of oppression and resistance. And you know, to this day, I can remember walking back and forth in that yard with Bob. You know, we discussed those words in what they meant to us, you know, and how we could fit in to what else was happening in the world in those days. And so we filed, you know, we filed a lot of cases. And then, I'm going to jump ahead a little bit. In 1968, in August of 1968, we had gotten a letter to the American Civil Liberties Union, which was just starting in Virginia. And in that month, Mike Millemann and Phil Hirschkopf, 2 American Civil Liberties Union attorneys, came over to the prison to visit with 3 of us. And they were turned away at the front gate. The warden of the prison stood in the steps and told them he wasn't letting any ACLU attorneys into that prison. So they went back to the United States District Court in Richmond. And the judge there was Robert R. Merhidge, Jr. He gave them a court order to go back to the prison and see us. And they brought us out one at a time. You know, I can still remember, you know, being brought out of my cell in chains, handcuffs, leg chains, waist chain, you know, and I had, you know, some legal papers in my hand I was carrying, and they would guard on each side, and they walked me down to the visiting room. And I don't know who had been first, but yeah, I really feel to this day that those attorneys saved our lives, you know. I hadn't seen Mike for 57 years until today. I'm going to jump ahead. We wound up winning a lot of cases in Virginia with the American Civil Liberties Union's help. You know, Mike will talk about this, but we ended bread and water diets in solitary confinement. And as a result of those cases, the entire Virginia prison system was desegregated. We ended Jim Crow in Virginia. Well, I wound up doing 8.5 years total in Virginia before making parole. And I moved back to Connecticut, and you know, within a year and a half, I had started drinking again. And you know, I'd never been able to control my drinking. And I found myself back in prison, this time in Connecticut, and for another 4 or 5 years. And during that sentence, you know, I stirred up enough trouble in that prison so they transferred me to Walpole in Massachusetts. And I wound up finishing that sentence in Massachusetts. I made parole, and I stayed here. I stayed in Massachusetts. And I lasted quite a few years outside, you know, like 3 or 4. You know, that was a lot to me at the time. And then I had another bout with drinking and got arrested again. And this time, when I was in jail awaiting trial, they called an AA meeting. People from outside came into the jail. And I'll never forget, wish I could thank him today, but this one of the speakers was an older guy. And he looked out at there was like 10 or 15 of us from the jail in that meeting, and he looked out at us. He said, if any of you have ever had a problem trying to stop drinking, you don't have that problem anymore. You know, whether you noticed it or not, you've been stopped. You know, and it was like you know, I never looked at it. It was like a light bulb went off in my head because, you know, I never could stop drinking myself. I tried many times. But he was right. We'd been stopped, you know, and there's a difference. And he said, all you got to do now is just not start again. And that was 38. And you know, somehow I just go on a little bit further. I wound up making parole, and in 1996 I moved to Boston, where nobody knew anything about my past. And I lived in Boston for 25 years until the beginning of the pandemic. In March of 2020, I hunkered down at home, like a lot of senior friends of mine, and in May, I got an email from a correspondent of mine way up in Yukon Territory in Canada, and she was reading a book called The Virginia State Penitentiary by Dale Brumfield. And she sent me an email and she said, Calvin, there's somebody in this book with your name. Is that you? And I had to sit down when I got that email, I'll tell you, but you know, I wound up getting the book. You know, of course, it was me in the book. So I wound up getting the book, and I got in touch with the author. And he wanted to tell my story. And he pestered me. You know, nobody in Boston knew anything about my past. And finally, I confided in a couple of friends, and they convinced me to tell my seniors group, you know, this is a group of like 40 people that I'd been hanging around with for 25 years, and nobody knew anything about my past. Well, the end result of the story getting written was I wound up in the cover story of Richmond Magazine, which is where the Virginia State Penitentiary used to be located. And a copy of that magazine got into, I didn't know what was going to happen when the story came out, but what happened was a copy of it got into the Virginia State Prison for Women in Fluvanna, Virginia. And the law clerk there, a woman named Shebri Stacy Dillon, read the story and was so moved that she had her daughter look up my address, and she wrote me a letter to thank me for what I had done 50 years before. And at the time, I was reading a book. It was called Our Class by Chris Hedges. And I asked her if she'd read the book, and she hadn't. And so I sent it to her through Amazon. And a whole list, about 12 different women in the prison wanted to read it after she got done, which got me thinking, I could think of a lot of books that I'd like to be sending into prisoners to read. And so that's how I got started sending books in, and I affiliated with the prison book program down in Quincy. And I want to say one more thing about Shebri, just to give a shout out. You know, we talked a lot about prison stay and about mass incarceration. She's doing a 30-year sentence in Virginia. She was arrested in 2016, first offense, nonviolent white-collar crime. The guidelines for that crime was 1 day to 6 months. Those are the guidelines that the judge had to go on. Not bound by them, but it was a guideline. Her lawyer and the prosecutor worked out a plea deal where if she'd have pled guilty, they would have given her 4 years. Well, she thought 4 years, knowing what the guidelines were was, so she took a risk and took a jury trial. And when she was found guilty, the judge sentenced her to 30 years. And I just wanted to get that out because she deserves a shout out. Mike, your turn.
Okay. So when I got invited to come to this conference, among the many attractions, besides the fact that it's such a wonderful program, was a chance to see Calvin Arey again after 57 years. Calvin and Landman, the law firm of Calvin Arey and Robert Landman, was a first-rate law firm. They won a lot of cases, and they established some really important precedent in Virginia. Calvin really has understated how horrible Virginia State Penitentiary was. There were no rules, so you could be accused of agitation, which was the major charge, or you could be accused of helping somebody with a legal writ and put in solitary confinement. There was no process, there was no hearing, and the punishments were grotesque. So Landman versus Royster took on all three of those things. It established requirement of rules, it established the requirement of a process, and it put off limits some of these obscene punishments like bread and water diets, taping people in solitary cells to the bars for hours. So it's hard to overstate how bad it was. Is my techie over there? We got an image? Can we put the image up?
Oh, yeah, where are the images? Thank you.
There's another part of the story that's important to tell, and that is when Phil Hirschkap and Phil Hirschkap's a fabulous lawyer. When we weren't let in, we didn't immediately go to court. We actually got on the street with a demonstration. And that guy in the front there, you may recognize him, this guy named Mike Millemann. And if you see the tan pants he's wearing, and I've got to admit that I've taken out the waist a little bit. But so our first step in opening up the Virginia State Penitentiary was to go to the street. So I found that in searching through my files before I came up here. So in a way of background, I was a law student in 1966. I knew why I was in law school. I was in law school because I could never understand organic chemistry. So I couldn't be a doctor. So that left being a lawyer. But I didn't understand why I wanted to be a lawyer until I spent the summer between my first and second year in the Louisiana Civil Rights Movement. I learned in the summer of 1967 why I wanted to be a lawyer, and I've been on that path ever since. I'll say a few words about Louisiana. They were still, in summer of 67, they were still lynching people. They were still, you know, the KKK was still in partnership with local sheriffs. The advice to us, when you go into a community to talk to the civil rights leaders, make sure that you're wearing regular clothes, make sure that you're driving a car with Louisiana plates, don't go downtown, go to the home of the civil rights leader, and go at night so that no one sees you. Because if the KKK and the local sheriffs see you, you're in trouble and your clients are in trouble. So some of the bravest people I ever met in the civil rights movement in Louisiana, one story that is not the most dramatic, I had a gun pulled on me, I got chased by the KKK one night, but in some senses, the metaphor for the civil rights movement was what happened when I went to the Louisiana Supreme Court Library to do research. And I had to use the bathroom, and I went to use the bathroom, and there were two bathrooms. This is 1967. Brown versus Board said you can't segregate schools in 1954. Two bathrooms. One bathroom said white males. The other bathrooms said colored males. Supreme Court, Louisiana, 1967. And what was important about the colored male sign is that it wasn't a sign. It had been individual letters that had been put up, the C and the O and the L, and they had taken them down, as they were required to do. But the stain in the wood from those signs was so deep that it left the sign up, and the metaphor is our job ever since has been getting the stain out of the wood. And that's what I think a lot of today was about, talking about how to get the stain out of the wood. So anyway, I went from Virginia to the National Prison Project as the first staff attorney, but I went to Maryland Legal Aid Bureau where I began filing prisoner rights cases. It was a heady time. We had fractured the hands-off doctrine, which said that federal courts had no role to play in prisons. There were judges who were finally doing something about these horrendous conditions. And it was the era of the Earl Warren Court. You had a good idea, you turned it into a motion for summary judgment, and you won. So it was a different time, it's needless to say. But after having been very successful at the Legal Aid Bureau, I went to teaching at the University of Maryland Law School. And looking back on it, what I was teaching with in many of the courses is the thing I wrote about retrospectively about the summer of '68 in Virginia. And I was talking about what we had learned. We learned about the civil rights movement, about how to draft emergency pleadings in the back of a usually speeding car. We came to understand the imagination seasoned with chutzpah that you need to be a really good civil rights lawyer. But, and this is the important part, most importantly, we discovered in our clients that endless reserve of human dignity, strength, and spirit that would motivate us and animate our legal work for years to come. And that's what I heard all day today. I heard impressively about that human spirit, about that dignity, about that intelligence, about people who endured and were models of hope when there really was no reason to hope. I'll give you some examples, and I've taught with that ever since. So I've taught a criminal law course, and in the criminal law course, we represented women who had been abused, some terribly, by their abusers, and it killed them. I'll give you one example and talk about what we learned in that case. We had a client, I'll use her initials, BB, who was beaten up by her live-in boyfriend. She went back to him. He got her down on the pavement one night and broke out all her top teeth and bottom teeth with the butt end of the screwdriver. She went in the hospital, came out, went back to him. This time he opened up her legs, poured kerosene between her legs and set her on fire. She goes into the hospital, comes out, goes back to him. And then one night he hands her a gun and he says, "Shoot me." And she says, "No, I'm not going to kill you." He says, "Shoot me." And she says, "No." And he says, "Remember Sophie, our daughter, who died of crib death? I killed her." She shot him 6 times in the head. So, the law of self-defense, based on male-male combat, is that in this long movie, you look at that 1 10-second slice. He doesn't have the gun. She's got the gun. He's saying, "Kill me." She's saying, no. She has time to premeditate. She premeditates and she kills him. Now, in this case, we were able to convince the prosecutor to dismiss the charges for obvious reasons. But there's a case that shows the limits of self-defense. We represented, in another criminal law course, we represented women who had killed their abusers and wound up in prison and in the parole process. And one of those clients was a woman who had been raped and jumped out a second-story window after having been raped, stopped the rape. And she had an ex-boyfriend who she didn't want anything to do with, but was trying to win her back. And so he hears she's been raped, and he goes to her and he says, "Who did it?" And she's walking down the street, and she points at the guy. He pulls out a gun and kills the guy. She gets convicted of murder for accomplice liability because she pointed the guy out. She didn't know he had a gun. She gets a life sentence. We get her out. So that teaches something about accomplice liability. You put accomplice liability together with the felony murder rule, you've got lots and lots of people serving life sentences who didn't intend to kill, didn't have any role in the killing, etc. I got a letter from an inmate named Walter Arvinger who said that he was innocent. It was about a paragraph long. I answered all my prisoner letters. I said, "Send me a transcript." He sent a transcript. He was tried in a capital case. The transcript, the whole trial, was 91 pages long. The trial lasted 3 hours. He was convicted, even though his only role, he had no role in the murder. His mistake was that he took some of the money from his friends. He wasn't even there. He was down the street when it happened. So he got locked up, and we got him out. We got him out after using his case to teach students how to write. You know, faculty conceive of all these theoretical problems to give to the students to teach them legal writing. So we decided we'll give them a real case. We'll give them Walter Arvinger's case. So Walter Arvinger, we drafted the post-conviction petition, we drafted the legal memorandum in support of it, we drafted the appeal, we drafted a clemency memo, and we finally got him out on clemency. And that resulted in David Simon and Ed Burns, who did something called The Wire. How many people know about The Wire? Yeah, so they came to see us, me and my students, and said, we just saw you got Walter Arvinger out of prison, we got a guy we want you to try to get out of prison who's known as Omar, the real Omar, Donnie Andrews. Now, Omar was a protagonist in The Wire who robbed drug dealers. The real Donnie Andrews robbed drug dealers. But the real Donnie Andrews was on the street at age 13 and became an enforcer for a drug organization and wound up killing 2 people. In today's world, you're looking at LWOP, life without parole, huge record, double homicide. Donnie Andrews goes into prison and turns his life around like you heard today from all these people who've done the same. We got him out. He came out, set up a charitable organization for kids, and proved to anybody who wants to pay attention that the life without parole sentence, which has metastasized in my professional lifetime, thousands of people, that sentence, that deadly, evil sentence, is totally unnecessary, because the people who wind up getting it and have the same stories as the people you heard today, have the same stories as Donnie Andrews. So I'm going to end, I could go on with lots of different courses that I've taught with students learning from clients stories, learning from courage, learning from intelligence, learning from maintaining hope when everything is hopeless. So I want to end with sort of my last major project, and this is going to take a second to spin out. Maryland, for years, this is one of those, none of you are really old enough to know who David Barry is, but Dave Barry was a humorist who used to always start out columns by saying, believe it or not, this is true, so I'm about to tell you is true. At the end of a criminal trial, when the evidence was in and the case was ready to go to the jury, the judge, until 1980 in Maryland, would turn to the jury and say to the jury, you are the judges of the facts, as all juries are, but in Maryland, you are also the judges of the law. So whatever I tell you about the law is advisory only. You have to decide what the law is. Again, believe it or not, that was the instruction. It took until 2013 for our highest court to say that violates the Constitution. That makes the burden that the government prove guilt beyond a reasonable doubt a good idea, not a requirement. And it guts the presumption of innocence. A lot of people think if you come into court, you're wearing a prison garb, and you've been accused of doing a crime, you're probably guilty. And who was on these juries? These juries before 1980 in Maryland were all white because blacks were stricken from the big panels. Or if they made it through the big panels and there's a black defendant, they were stricken from the jury. And in Maryland, when these folks were being tried, 1960s and 1970s, I'm going to come back to the 235 folks that we wound up representing with the Public Defender's Office. Back in those days in Maryland, in 1964, George Wallace was the governor of Alabama. Segregation now, segregation tomorrow, segregation forever, ran as a candidate in the primaries and came to Maryland, and he got 43% of the vote in Maryland. So the juries were all white, all the blacks were gone. 43% of the jury had voted for George Wallace, and they were told, you get to make up the legal rules. So what happened? We had a lot of black people serving life sentences for murder and rape, 235, and we got to conduct this wonderful experiment. They were all entitled to new trials. New trials, 2013, it predated 1980. So took a while, but negotiating with prosecutors, they finally decided it didn't make a lot of sense to try somebody who was 55 or 60 or 65 or 70, particularly if they performed well in prison. So we negotiated the release of, we here, the heavy duty was the public defender's office. We helped out with a number of the cases. We negotiated the release of 200 out of the 235, and the other 35 we couldn't get released for various reasons. They had detainers to other jurisdictions. They were too old and too infirm to really come out. They had to go to nursing homes. So just pause for a second. This is what I tell audiences when I'm talking about this. Imagine you go into a prison and you go into a cell block that's got 235 prisoners, all convicted of murder and rape, and you're told you have to open the doors of 80% and let them out. The public response is, oh my God. As you might expect, they came out. Now, I'll come back and add one other fact to the story. They came out and they stayed out with a 97% success rate. They weren't cherry-picked. They weren't recommended for parole, or they were, but they didn't get parole because the governor in Maryland had veto power, and after the Willie Horton mess, the two liberal Democratic governors in Maryland who served 4 terms together wouldn't parole anybody. So they all backed up. But they came out. We had a social work component. We worked with social work students to make sure that they had individualized reentry plans. But most importantly, really the most important thing that happened is they formed a community as they came out. They came out in 5s and 6s over 7 or 8 years, where they understood that they had responsibilities to everybody left behind, because they realized that if they screwed up, this exercise was going under, because judges would stop approving releases, the Court of Appeals would rethink it. So they understood it, and their motto, their mantra was failure is not an option. And they created this wonderful community that endures today. And they helped each other. They welcomed, as people came out, they welcomed people out. They provided support. They met monthly, and they created a community like I saw today, like the community I saw today, that makes such a huge difference. So, what my students learn from all this is there are a lot of people who have an endless reserve of human dignity, strength and spirit that would motivate us and animate our work for years to come, intelligent, dignified, wonderful people. And my students over the years have learned from those of you who've been in and those of you who've been models of integrity. Thank you.
Thank you, Michael. Liz, is this working? I don't know. Take this one. I'll turn that on. Yeah. Yes. Oh, it was. Here, no. Take this one. Yours is on. Mine is on.
Hello? Oh, yeah, that's working. Okay. Hi, everyone. Again, my name is Lizz Matos, and that was very entertaining. A lot of really interesting stories. Thank you both so much for that. I'm not going to have the same stories with all those wonderful twists and turns, but I very, very much appreciate being up here with Calvin and with Michael. This was a great learning experience to be up here with them, and I'm honored for all the work that you have done and who you are as people, and I'm honored to be up here with you. I want to start out by saying that I'm speaking on my own behalf today, not on behalf of the Attorney General's office. And I also want to preface everything that I say today by saying that, none of us would accomplish the things that we have accomplished or achieved, even just moving the needle forward. We don't do those things on our own. We do those things in community, the kind of community that Michael was just referring to, in coalition, in dialogue, in working through difficult decisions together. But all of the work, and I'm not speaking for you, although I'm sure this is true for you as well, but certainly for me, has been done on the shoulders of others and in collaboration with others, and is, as you all know from what you've heard today already and what brought you here, that this is a very long journey towards where we need to end up. Important collaborators, I just want to mention some specific people. And the drivers of change, of course, are folks who are behind the wall, folks who have come out and who continue to do this work and tell their stories despite how painful it is to relive that. And the many, many loved ones who experience the inhumanity of prisons along the way, with those who are behind the wall and even after they come out. And then there are some very specific groups of Families for Justice's Healing. You heard from Tracy Borden today, many people doing reentry work, particularly those who experience reentry firsthand, who are doing the real work on the ground to get people acclimated when they come out, because a lot of that doesn't happen when you're incarcerated. Also restorative justice programs, religious organizations, but also institutions, legislators, our Congresswoman Presley, Congresswoman Warren, Congressman Ed Markey. These are all people who are helping to move the needle forward in lots of ways. So I just want to make sure I mention all of them, and of course students who are leading the charge on many, many things. Public defenders, social workers. I mention that because when we say community, community means different things to a lot of different people. And we can do all the organizing we want, but the truth is we need people who are in positions of power and all along the way to make things happen. Because ultimately, this is a system that is very opaque and lacks both transparency and accountability. And I'll talk about that a little bit more later, but those two things are very clearly interrelated. So I'll just start by talking about a few things that I personally have been involved in my journey when I was at Prisoners Legal Services, and a number of things I continue to be engaged in my current role. One is the ending, I would say almost ending, because we still have a few things to fix, of prison phone calls, of charging families and incarcerated people to make phone calls to stay connected to their loved ones, which is a lifeline for them while they're incarcerated, is 100% related to successful reentry and 100% related to just health and sanity while, to the extent you can have sanity while incarcerated. So that, I worked on that from the very beginning of my days when I started at PLS, and it got brought over to the finish line after I left, and very recently, and continue to work with folks to make sure the intent of that law is realized and that people also don't get charged for video calls here in Massachusetts, or for sending emails, which will still get charged 25 cents per email. So that all needs to be addressed as well. There's also JurisLink at Plymouth County, which is where the detention facility is in Massachusetts. Is JurisLink costs upwards of $30 per call between lawyers and incarcerated people. So for folks who, whether you're a detainee, ICE detainee, or on the sentence side, pretrial, majority of people are pretrial there, you're paying, your lawyer has to pay $30 to represent you. Now you're entitled to a lawyer, obviously, if you're facing criminal charges, but not after that, right? You're not for your appeals and all of that. And on the ICE detention side, you're not entitled to a lawyer. So you're effectively foreclosed from getting access to an attorney because of these very high costs. So there's still a lot of work to be done in this area in Massachusetts and beyond, certainly, because Massachusetts is still within a very small minority of states that has eliminated charging of families and incarcerated people for phone calls. So lots of work still to be done there. And then I have to mention the 2018 Criminal Justice Reform Act, which was imperfect at best, but did contain a lot of really important things. I'd say one of the things that I'm most proud of that I worked on and got to see across the finish line is the institution of medical parole in Massachusetts. At that time, we were one of only 5 states that did not have medical parole, which others call, there are other words for it, but basically in Massachusetts, if you're permanently, physically, or cognitively incapacitated, you can petition for release on medical parole. So there are many problems with how that gets interpreted, and the process itself is a parole process rather than just a release process, or release from your sentence like it is in some states, or like it is in the Bureau of Prisons, for example. In Massachusetts, you are, still released on conditions, and so some people's parole being revoked. One problem with that is the way that's being interpreted in Massachusetts right now is that the revocation, there aren't really enough due process protections or the same due process protections if your parole was revoked outside of the medical parole process. So there are things there that really need to be fixed. However, medical parole in the years that it has existed so far has resulted in the release of many people who were very sick and were not getting the treatment that they really needed while incarcerated. And the numbers have been going up every year. I could say more about that. There's still some problems there, like there are with all of these things, but definitely a step in the right direction. The Criminal Justice Reform Act also had really important protections for LGBTQ plus folks. It ensured that, I shouldn't say ensured, it provides for people to get gender-affirming care, which includes being placed, if they choose, in a facility that matches their gender. There are certainly people who are, like for example, trans women who prefer not to be in a women's facility and vice versa. It's people's choice, but that is something that really started after a passage of the Criminal Justice Reform Act. Imperfect still, but I will say that in addition to when we had to file a lawsuit to get the first woman transferred to Framingham, a trans woman who had been trans for many, many years and presented very much as a female and was stuck at MCI Norfolk, eventually did get to Framingham, and others after her, after we filed that lawsuit and won the lawsuit, were also transferred to Framingham, and there are trans women there now. In addition, another thing that many had to sue for, but eventually did happen largely because of the law changing, is access to surgeries. So that is something that has finally happened in Massachusetts too, but really just within the last couple of years. And the third thing I'll mention from the Criminal Justice Reform Act, although there are many others that are relevant to this space, is solitary confinement. So it has changed certainly since the bread and water days that Calvin had to endure many years ago, but in all the years in all those years since, it has certainly not changed enough. And the true intent of the Criminal Justice Reform Act language, which was to really exclude people with mental health issues from a solitary, and to get prisons and jails to actually invest in mental health treatment instead of placing people in solitary confinement. That vision hasn't really been realized in Massachusetts, which I'm sure many of you know. But one other thing that we had wanted to happen but did not pass in that bill because of negotiations that did not pan out the way we wanted them to, but was ending the DDU, the Department Disciplinary Unit, which started at Walpole and did close. However, this is a theme also that Calvin and I talked about, and I'm sure Michael's very familiar with too. Oftentimes things change, or they're shut down, or supposed to be eliminated, but really they just transform and they're called something else and they continue by another name. And that is, I think, in a nutshell, a lot of what's happened with solitary confinement, not just here in Massachusetts, but around the country. I also will just mention a few cases that I've been involved in. I mentioned the case of the trans woman, and that was a case filed with GLAAD and with Goodwin Proctor, and did result in the first trans woman being sent to Framingham. In addition to that, ending the practice of charging people with escape for mere possession of a cell phone. I did a series of cases, and there's classification cases, but the reason why this is so significant is because in Massachusetts, if you get caught with a cell phone, you're charged with an escape or possession of an escape tool, and that gets you what's called a level A status. And level A status is essentially being in extreme confinement. You are on lockdown, you have to be shackled, not just your hands, but your legs as well. You have 3 officers escorting you everywhere you go for really what is nothing. I got a case where the client had a non-working cell phone. The cell phone actually never worked, and instead of just charging him with possession of contraband, which is what it should have been, got this really high-end disciplinary sentence for possession of a broken cell phone. So there were a series of cases around that, and then the deaf and hard of hearing case was really getting accommodations for deaf and hard of hearing folks who are incarcerated, including just basic sign language interpretation. And this case lasted 12 years. It was just actually, the case was finally fully settled actually after trial. So it went to trial last year on the issue of fire alarms. Fire alarms for deaf prisoners was the sticking point in this case, unfortunately. But they did win, and there will now be strobe lights and appropriate fire alarms for people who cannot hear in prison. In addition to that, solitary confinement around people with mental health issues at Bristol County Jail was another case I was involved in, which also just only recently settled after many years of litigation. Shifting the makeup of the parole board, excuse me, was not something that I litigated, but is something that we worked on in coalition with many others, including some people in this room, to push back when people were being recommended for the parole board who really didn't have the requisite skills or the skills that the parole board really needs in order to make comprehensive, well-informed decisions about who should be released on parole. A few other things I want to mention. This looks like a lot of words, but I'm going to go through it really quickly. Some things that I did while at PLS, but really internally, that I think matter, and I think will continue to matter. And one is, I think this helps show, the reason I say it matters is I think what you do internally in an organization, what the culture of the organization is, what the people look like, affects the kind of work that you do and affects how the work is exhibited both politically and publicly. So we had a number of projects that I started and created space for, invested resources in, and again, in collaboration with others. But we started the first ICE detention conditions project, which is still there today, and doing a lot of work in a obviously very busy space right now. A women's incarcerated women's project, which really needed dedicated resources because women, although they are a minority of folks who are incarcerated, have very, very specific needs, and the issues facing women who are incarcerated. You heard Michael talk about women who killed their abusers. That is a significant portion of the population at Framingham, from people who fight back or defend themselves to who end up, unfortunately, being part of even some felony murder or didn't actually pull the trigger or kill them themselves. But there is a significant population of women that fit that description who are incarcerated. So the Incarcerated Women's Project really focuses on trauma and women's specific needs. Then the other, I would say, is the Race Equity and Corrections Initiative, which MAC who you heard from earlier today, is a part of, and Mac was a board member at PLS for many years. I worked very closely with him, and I'm very happy to have hired him. One of the first things I did when he got out. And I think that matters too. We have a number of formerly incarcerated people that are at PLS, in that it matters in terms of building relationships with people and how the work shows up, how you show up in the work, and how the work is felt, the impact, actual impact of the work. So I wanted to make sure to mention those things. In addition, I really wanted to focus just for a few minutes on lessons I think I've learned in doing this work, and this is obviously a lifetime journey in learning. But these are systems that need to be transparent and accountable. It's something I mentioned earlier. And I don't think you can have accountability without transparency. And so a few things I want to mention there is, so for the first time, I believe last year, for the first time, incarcerated people testified directly before the legislature. It was virtual, but they testified directly before the legislature, and that took a lot of work. It was years, months and years of work to convince the legislature to allow that to happen. And it's not something that's enshrined, so that needs to continue, because it was a game changer. For the first time, legislators were hearing directly during a legislative hearing from incarcerated people about bills that impact them directly. And that was huge, yes, definitely. It's and something that needs to continue, and I think goes to the transparency and accountability issue. It's much harder to pass a stupid bill that does nothing for people who are incarcerated when those people are directly before you and you see that they are not this inhumane, demonizing, all of these images that are conjured up by the media and the public, and it's much harder to just throw people under the bus when you have to engage with them. So that's really important. The other thing that we were very intentional about putting resources into is getting legislators to go into prisons and jails. Legislators have the statutory right, entitlement to go into prisons and jails. Elected officials generally have that right, but it was very underutilized, if hardly ever at all. And that really changed in 2020 when there was a horrific crackdown at Susan Baranowski Correctional Center at the maximum security prison. And the systemic, horrific crackdown, like cell to cell, just beating people up. And we really pushed legislators to go in during that time, and continue to push. And I think legislators are going into prisons and jails much more now, but we need to keep the pressure up on that as well, because it has shifted the conversation within the legislature in Massachusetts in a way that was notable from when I started to now, but it's still not enough people. So that was another thing that I wanted to mention. And then just a shout out to the participatory defense folks, people who are going into court and showing up for people's criminal hearings, people who are going into parole hearings and being present. It really matters. It matters for the decision makers to see people in the room and see people who support and love and care about the people there, because they know that they're now accountable to the people who are sitting in the room, and it's not just this one person. So another thing I wanted to highlight that I've observed is actually effective and important. And of course, the reason that many people are here today, education, there's clearly not enough. And just since I mentioned Framingham is, that's where the women are. There's no bachelor program available to women in the entire system, only to men, and still not enough for men. But women don't have that opportunity at all in Massachusetts. That's something we're looking into changing. But education is a game changer. I'm not going to say much more about that because you're hearing about that. But it shifts people's lives. And what I will say is one of the things that we hear in terms of pushback is like, well, why should they get this when, the correctional officers haven't even have the opportunity to go to college? My answer to that is they should go too. It can't hurt. So, there are resources for that. We just passed, free community college, so I see no reason why it shouldn't be accessible to everyone. And then just in terms of what I'm doing now, I am trying really hard to lay the foundation for the Attorney General's office to do important work in this space. I can't talk about any of the ongoing investigations or work that is happening right now, but can tell you that I feel definitely allyship with the person who is at the helm right now with Attorney General Andrea Campbell. And I think we're making progress. And finally, I just want to say thank you, Manisha, for having me here, for all that you do. This is really incredibly important work, and for creating this space to talk about these issues today and tomorrow. So, thank you.
Thank you so much, Liz. Okay. Borrow this for a second because it takes a minute to heat up. Thank you to all three of the panelists for sharing your insights, and we do have time for discussion, so I want to invite questions. I don't know, do we have a roving mic, Betsy? Betsy's going to get a roving mic. And since we are live streaming it, so if you're live streaming, thank you for listening, and the sessions are being recorded and will ultimately be packaged and put on the EPI website. So please do wait for the mic. And so let's see, I think we've got a hand over there, and Beth, just flag down Betsy if you want to ask a question or make a comment. Okay. And feel free to introduce yourself as you.
Do I have to stand?
If you don't mind, I mean, if you don't have to.
My name's Juanita. I always introduce my profession. Don't worry about it. I'm from Dorchester, but I actually advocate in Virginia, so I'm very much aware of how Virginia is, because I had a friend who was incarcerated in Virginia for 24 years, and he was pardoned by Governor Ralph Northam 3 years ago. But I just wanted to make a comment to you, Calvin. Your friend who's incarcerated right now for the crime that's nonviolent, there's an earned sentencing credit bill that passed in 2021 that came into effect in 2022 or 2023. She can go to her counselor and ask about it, earned sentencing credit. And if she's been doing well and she's behavioral-wise and everything else, she should be able to get some time off of her sentence. So have her look up earned sentencing credits.
She has.
Oh, okay.
She got convicted in 2016 with a 30-year sentence.
Okay.
And with that credit, her discharge date is July 14th, 2036.
Oh, my goodness. Okay.
It's like knocks 10 years off, but still that's
still not good.
That's
Well,
not good.
I will tell you that we are trying to work on second look legislation in Virginia right now. And if anyone's not aware, second look is where someone goes to see a judge and petitions to get a second look at their case.
Right.
Where a judge can determine if that person has spent a reasonable amount of time in prison. We've been working on it for 6 years now. I still legislate in Virginia. I want to do legislation here because I'm from here. But I know the landscape there, but we're working on it. So maybe we can do something and she can come home at some point. So I do wish her luck. But great work.
Let me tell you about one more Virginia case. Terrence Vaughn. This is the second person I started sending books to in Virginia. At the age of 19, he committed a crime, and he was offered a plea deal of 19 years. At the age of 19 years is a lot. So again, he pled not guilty, took a jury trial, was found guilty. The judge sentenced him to 49 years. And this, I could go on.
Hi, thank you very much for all of your thoughts. My name is Carol, and I'm with Paretakers. I mentioned earlier I mentor somebody in the EPI program. And so my question is, what advice do you have for how we can advocate for those people who were incarcerated under the felony murder rule prior to the Commonwealth versus Brown 2017 case, which limited the rule which limited the rule where intent to kill had to be shown, because as far as I'm aware, the person that I mentor, there was no intent ever demonstrated. And I don't know how to advocate. I just
So there are probably people in this room who have more details than I do, but I'm pretty sure there is a bill pending right now that would address felony murder charges. I'm not sure, I know there was some discussion about retroactive versus prospective, but unfortunately, I'm not in the weeds on that, so I don't know for sure. Is there anyone here who's working on that? I think Mac might know something about it. He left, but I think there are definitely people, because I know there's a group at Norfolk who worked with folks on the outside to get that, to get that submitted. So I would look into that.
okay. Yeah, I know. I believe Erica Oderhoven was thinking about this area, but I haven't heard of anything yet. Maybe I'll talk to Mac.
Okay.
Thank you.
Well, this is, my name is Bob Nesson. This is a question not so much about legal issues, but I went to a Harvard GSD architecture talk about dismantling Framingham. Do you know anything about that? Is that prison going to be dismantled and replaced by a kind of a building that would encourage learning and rejuvenation? Do you know anything about that?
I know a few things about that. So does Betsy. But I don't know anything about current plans to do that. I have not heard about movement on that, which is probably good. And I will say that there are different feelings about this issue, but there is a lot of movement and organizing around not creating a new women's prison, which I think was to the tune of $50 million. And actually there was a moratorium bill that passed the legislature, but then was vetoed. Not in the prior session, before the prior session, I think, 2 sessions ago. And so there's still more to come on that, but I don't think that is, I don't know, Betsy, if you can say, I think the moratorium bill was refiled, and so that's still pending, but I'm not aware of any current plans to tear down Framingham.
Thank you.
Yeah, I think Andrea James was a panelist on that, and Andrea James' life's work is to end the incarceration of women and girls, and so her work through Families for Justice Healing and the National Council for Incarcerated and Formerly Incarcerated Women and Girls has been fighting for years in all sorts of ways to stop new women's prisons from being built and to invest in alternatives. So my guess would be that Andrea was describing her vision and her goals, but it's not like a formal plan that I've heard anyone in government talk about.
Yes, I have a question regarding the medical parole or compassionate release. Obviously, when you're incarcerated, your health care is the responsibility of the state. What is the state doing to ensure that if they are getting medical parole, that they're not being released to not have coverage?
Right. I just want to make sure I heard the question okay. It's about people who are being released, who are approved for medical parole, but who are not being released because of placement issues?
It was people who are, it was about the medical care of people who are released on medical parole.
Oh, yeah, I don't know. I think people should have, so one thing I didn't mention is that we are doing some work, and some people who were here throughout the day have been to some of these meetings in the reentry space, and have talked about the lack of access to real mental health care for folks when they come out who really need specialized care. People actually understand what that experience is like and how it impacts them on reentry. So I could say there's been an acknowledgement there. I mean, people coming out should have access to, mass health and healthcare, and through their, insurance. But it is, I don't think it has been adequately recognized by the healthcare system that it's really like a specialized practice, that people really need intense services when they get out, and from people who actually understand what that experience was and who aren't going to objectify them or, blame them for their own experience or whatever it is. People have a lot of trauma that they need to unpack. But, this is sort of goes to a bigger question of just the lack of mental health care generally, both inside and outside of prisons and jails. So I can't speak specifically to that, but I know there are conversations happening around trying to get more services for folks as they come out in that space and not just leave them to their own devices with like their insurance and the healthcare system that they have to figure out how to access on their own. But there may be others here who have more information.
Hi, Reiko Hillier. It's such an honor to be part of this extraordinary reunion with new connections and old connections, and to see this collaboration across the walls and across time and across regions. I'm just so moved. But I had a little piece of info or context that might be useful. I don't know. I was so excited to hear about legislators coming into the prison and folks being able to testify, and how important that interface is. I completely believe in the transformative power of those encounters. And it is not the first time, because throughout the 70s and 80s and early 90s, incarcerated people who were convicted of felonies were allowed to vote while they were in prison. This was true until the year 2000. This is my next project. Stay tuned. And so legislators went inside prisons regularly, and incarcerated folks had a regular day several times a year called Legislative Awareness Day, where they held essentially town meetings inside the prison with state legislators. And folks who were incarcerated did testify in the state legislature, and they debated politicians and judges on television. The folks who were the victims of William Horton's rampage, quote unquote, his crime spree while he was on furlough, these victims who were not murdered, it was a sexual assault, and as traumatic as it was, people refer to it as a murder. It's not a murder. And they appeared on television regularly to call for the most harsh crackdown on furloughs. And it was Omar, who was sitting here earlier, who debated on television against them. So it was more common before. It's remarkable that you're restoring this, but it will help persuade people to crack the doors open even further if you remind them this actually isn't that new. And that our lifetime this used to happen, and the walls, and the world didn't fall apart.
Yeah, thank you
well, maybe
so much
it did,
for
but for
raising
different
that.
reasons.
Yeah, it's so true. I feel like it's another world. But yeah, there were furloughs, and people would come out who were doing very serious sentences and earn the right to furlough. And it was a very successful program. The Department of Correction itself had many studies talking about how correlated it was with lowering recidivism rates. But,
They worked at the State House.
yes, yeah, absolutely. So thank you for correcting that and raising it. But yeah, no, it's true. Another lifetime, but it wasn't that long ago. You're right.
There are still legislative awareness days that happen, and I know this only because sometimes it poses a scheduling conflict to the Emerson Prison Initiative in, like, if we're planning an event or something and someone will say, oh, you can't do it that day because that's Legislative Awareness Day. So although incarcerated people in Massachusetts cannot vote at this time, there is still this tradition of Legislative Awareness Day where legislators will come in and debate the issues or provide space for people to engage with them. And I don't know the history of that at all. I just know it's been a scheduling irritant. So it's fascinating to put that in context.
I wanted to ask Calvin a little bit more about the book project. If you could tell us a little bit more about that, Calvin. I think something that I've noticed in hearing Michael and Lizz talk is these questions around severely incomplete like narratives and how they can be weaponized against people, or Lizz, kind of this idea of opacity and euphemism being weaponized. You know, I'm just thinking about, even in my time working with EPI, how I've heard solitary confinement be renamed with different acronyms, you know, because we can't refer to it as that, and just like that slight opacity, how impactful how it's used, you know, and I wonder, Calvin, if you could tell us a little bit more about your project and maybe the ways in which just books are helping people maybe complete some stories, or be a little more see transparency, break through the opacity.
Yeah, I'd be happy to. Like I mentioned, the first book I sent was to this woman that responded to the magazine story about me. And then I began sending her more books. And the same thing happened with all these books. Other people wanted to start reading them as they arrived. They saw her reading them and would sign up. She actually formed a list. You know, she thought that was the fairest way to do it. And after about 3 or 4 months, I had the bright idea of seeing if I could replicate this with, you know. So there's a publication in Virginia called Unlocked. It's a collaboration between Virginia Tech and an organization called the Coalition for Justice. And they publish submissions by prisoners, you know, poems, prose, you know, little articles. And you know, it's sold on Amazon for like $4.98 or something. It's not an expensive publication. It's got 60 or 70 pages. And I got a copy of that, and I started reading the submissions, looking for something that would resonate with me. And when I found something, I would contact that prisoner, write him a letter, and I'd send him a copy of that story and describe my conception of a freedom library. You know, I was in the South during the Civil Rights Movement, and I know, you know, black people weren't welcomed in public libraries. They started freedom libraries in the back of a house or in the back of a store, and they would gather books and circulate them themselves. So my idea was to do just like Chevy was doing, send books to one prisoner and have them circulate them. No prison officials involved. You know, it's, you know, we just, you know, here's an ex-prisoner outside, and I know I should be using returned citizens, you know, sending books into somebody who's now serving time. And so that's what I started doing. And then that fella, after a couple, 3 months, he recommended 2 other guys that he thought were, you know, solid guys that he'd done time with, but were in 2 other prisons. And so, you know, before 6 months had gone by, I was sending books into four different prisons, and it grew from there. At last count, I sent books into 14 prisons in Virginia, and to date, I probably have about 1,000 books circulating. You know, and these are books like, you know, I'll give you an example of some. Besides Chris Hedges' book, Our Class, there's Solitary by Albert Woodfox, Man's Search for Meaning by Viktor Frankl, Yes to Life by the same author, Viktor Frankl, A Question of Freedom, Dwayne Betts. You know, books that The Sun Does Shine. These are most of the books that I tend to send are books that they resonate with me because I've been in prison, and they're books that I would have wanted to read when I was in, and they're books by people who've been there and have come out in their lives. They've transformed themselves, and I find those are the books that resonate with the people I send them to. You know? And then I affiliated. Go on a little further. I was doing this on my own. You know, I'm on Social Security, but I have some friends that had some money, and they were helping me along. But I affiliated with the prison book program down in Quincy, which also sends books to prisoners, but they respond to prisoner requests. They get thousands of letters from prisons all over the United States, and they do their best to fulfill the requests that the prisoner is asking for. So you can see the difference between, I mean, they affiliated with me, but you know, I joke when I'm down there talking to the volunteers, you know, when I say I send prisoners, I find my own prisoners and send them the books I think they should read. You know, it's a little different than what they do, but it's been working.
Hi. So I'm from California, and a big issue recently, obviously, was the wildfires and how those were being fought largely by incarcerated people who were making something like 13 cents on the hour to risk their lives putting out fires. And I was just wondering if you could maybe talk a little bit about any connections that you see between that and the fact that for-profit prisons do still exist, and any efforts towards reform in that capacity and reform of the 13th Amendment that allows for that to happen. Also, thank you for all the work that all of you do.
So I'll take a crack at it. I'm not up to date, I've got to admit, on the various states' response to paying prisoners. I know it is a real variation. But, you know, unfortunately, prisoners have been captive labor, you know, since the first incarceration. And a lot of it comes out of racism in the South. A lot of it comes out of as a hanger-on to slavery. But I think there are some jurisdictions that are moving towards reasonable reimbursement. I think they're probably a minority, but you know, there's clearly a lot of work left to be done.
When I first went to the prison in Virginia, the Virginia State Penitentiary in '65, we got 15 cents a day for work, and they held back a nickel of that until you got discharged. So a dime a day, $2 a month approximately. We hated February because if they issued your money in $2 punch cards, and you know, at the end of the month of February, if you had like 18 days or 19 days, you didn't get a punch card until the following month. They carried it over, you know. So, but some of the prisoners I correspond with now can earn as much as $54 a month for, you know, they work, you know, 8 hours a day, 5-6 days a week, and $54 a month. And there's a lot of tremendous numbers of people are in solitary. I'll call it solitary. They have all kinds of different names. You know, it's just semantics. Restorative housing, meditation. You know, but they don't work. You know, if they're not working, they're not earning anything.
Yeah, I was just going to mention, there was a bill filed last legislative session. The legislative session in Massachusetts just started in January and runs for a year and a half, for folks who don't know. That Senator Cream filed, and I'm not sure who, if there was a House rep who filed a companion bill, but it was to have minimum wage for incarcerated people, is my recollection. And I don't know if she refiled it this session, to be honest, but it'd be good to look at. I don't think it was a unique effort in the country. So, you know, I think that effort has happened other places. I'm not sure if there's a state that's actually succeeded in passing minimum wage, but I know that it's happening. Like, there are people who are recognizing this is a labor issue, and for folks who don't know, there's industries programs in prisons, right, where these are the most desired jobs, but you're still getting paid peanuts. And we're, actually capitalizing and profiting off of the labor of folks who are incarcerated in these industries programs. Like at Framingham, women are making U.S. flags and embroidering flags and that kind of thing. And at Bristol County, they were making I think bulletproof vests or something for the military and things like that.
We'll take the last comment. I just want to say briefly that at the Department of Correction Central Office in Milford, there's a whole correctional industries store where people can come in and purchase things that are made in the prison industry. So that's still, very much something that is happening in Massachusetts. Yeah, last question.
Hello, my name is Carrie Peace, and I'm a former Boston Public School nurse. And I just want to go back quickly to health care with regards specifically to women and young girls who may be incarcerated. And you had mentioned that you're doing, I believe, legislation to make sure that they get health care after they leave the prison system. So what is the health care like while they're incarcerated? Do they get immunizations? Just what type of health care are they getting while they're incarcerated?
Mm-hmm. Yeah. There are folks here who have been there and who can talk about it. And but I'll say in Massachusetts, the contractor just changed. It was a contractor called WellPath, and it's now a contractor called VitalCore, but just on a very basic level. So it's different, and different states do it differently, but here in Massachusetts, first of all, we don't have private prisons yet in Massachusetts, but we do have privatized healthcare in prisons. And so what happens is the DOC, the Department of Correction, and then each county jail contracts separately for healthcare. So the DOC has one contract with VitalCore, and then each county jail, they operate separately because they each have their own sheriff, contracts separately for healthcare. Sometimes they have folks that they hire in-house to provide healthcare, like mental health clinicians and nurses. Some counties do it that way, but for the most part, they contract out to these big companies that are providing prison health care around the country. The contracts are not designed to provide the same kind of health care that one would be required to provide outside of the prison context. I will say that legally, the standard is shifting a little bit more to community standards of care, but right now it's a correctional standard of care. It's adequate health care, not necessarily what you need. For example, they just kind of pull people's teeth out. They're not trying to do root canals or any of that stuff. That's one example. Another is there's a lack of really adequate health care for the elderly, in particular cancer treatment, people with cognitive impairments, major deficiencies. And I think part of the reason is because these contracts are fixed rate contracts. They are, we're at time. So they get paid their flat rate contracts. So there's no incentive to provide quality care.
I want to say one word about this, maybe a couple of words. This is a chronic problem all across the country. There's great delay in getting to an infirmary. The private contractors, usually they're hired for 2, 3, 4 years, and then it's pretty clear that there's a disaster. They bring in a new contractor. There are people who develop, deadly diseases and can't get attention until it's too late. But this is a chronic, serious problem throughout the country.
Yeah. And then just very briefly, we'll invite a response.
So as a PA, I worked at Hampden County in Ludlow, Mass, as a physician assistant. And so when people came in through the facility, so those people were serving 2 years or less, what they'd come into is they'd come in and get a basic physical exam. We'd go over their health history, any medications that they were on. And if they had diabetes, it was a protocol for people with diabetes. There was a protocol for people with hypertension. But outside of that, I never did pap smears for the women. if we had to send a patient out, you'd have to have like a board meeting about like why a patient needed to be sent out. Was this patient going to get bailed out in a certain amount of time because the state has to pay for that, you know, the person to go to the clinic, and it costs them money. Also, too, correction officers have to go, so a lot of times they choose the safety over a person's health care. A lot of times in the prisons, for example, there's restrictive access. What does that mean? They have to see a nurse first who determines if they can see the medical doctor. And the nurse will often give them Tylenol or ibuprofen to soothe over their health issues, which doesn't do anything for them. I also see a lot of patients who are incarcerated that have inflammatory bowel disease. I've had to call South Bay or Nashua Street and wonder why my patient is not getting their biologic medication, why I have not seen the patient. So there's a lot of things that they are not getting. On mass.gov, because I just did a lecture on healthcare incarceration. On mass.gov, it says that they are entitled to mental health care, they are entitled to physical exams, they are entitled to dental care, and they are entitled to substance abuse care. That is not always there. Most of the time it is not there. So that's how the care is, subpar.
I would like to take the last 3 minutes and just offer a couple closing reflections at the end of the first day of this conference. Before I do that, please join me in thanking the panelists. Thank you again for all of your insights. And so I just want to offer my takeaways, a few of the things that I am carrying forward from this conversation tonight. The first, Michael, your description of they didn't get the stain out of the wood the way that white supremacist practices are baked structurally into the very foundation of our buildings. I think the work that so many of us who have attended the conference today, what we're doing is trying to get the stain out of the wood, to do this structural work to deeply excise the way in which the poison of white supremacy has maintained the social structures in which we operate. So that was a really evocative metaphor, I think, or description of reality that I'm using as a metaphor, I should say. Calvin, I was struck by, you said something like the ACLU was just getting started in the 60s or 70s, and it just made me think about how we need to not take the rights we have for granted, that every right that we have is there because rights activists fought for those rights, worked for those rights, labored for those rights, and the story, and even Michael, your joke about the law firm of Arey and your colleague, like we have the rights that we have today because people have worked for them. And so at this moment more than ever, but at every moment in time, remembering that we need to be vocal about the rights that we believe in and we want to have. And I am thinking about not being able to answer the question of the partaker's mentor who is here of what do I do to support this person who's in this legal situation? Even if we're not sure exactly what the solution is, voicing our concerns to our elected representatives is something that everyone should do. I know there's a class of students here, so I think it's also important to say this when folks are young, developing the practice, the habit of contacting your representative is something that I encourage everyone to do. You want to speak to that?
Yeah, just one word about this. Probably everybody in this room is aware and has read the 13th Amendment to the Constitution. But many people feel, slavery was abolished at the end of the Civil War. But if you read the 13th Amendment, you see that there were exceptions. And the big exception was anyone convicted of a felony, And, Manish is exactly right. Any rights that prisoners have gained over the years have been as a result of struggle.
Yeah, thank you, Calvin. So complacency is not an option because the rights will go away if that is the path we choose. The third takeaway for me, and this is how I want to end the night, is to celebrate the victories, to celebrate the things that have worked. And Liz, you gave examples just of things in Massachusetts' immediate reality. So cost-free phone calls, medical parole, and the being able to zoom in incarcerated folks to be able to testify in front of the legislature in real time. I mean, these are things that might feel tiny but have huge impact in ways that we're only being able to follow in real time. So whatever the victories are that we identify, celebrating them and being in community about them and supporting each other as we do this really hard work is so important. So thank you all for being here. Thanks to our speakers, and I hope you'll be able to join us tomorrow, anyone that you can, at the Film Fest that will be in the Bordy Theater starting at noon tomorrow, running from noon through 8 p.m. I'm sorry, the Bright, thank you. I was getting a head shake. Not here, not in the Bordy. If you're on live stream, not in the Bordy, but in the Bright screening room in Paramount. And tomorrow will not be live streamed, it's only in person because it's showing films. So show up in person if you can and join us for that day. Thank you so much.